Hello, everyone, and welcome to Clat. In today's class, we are going to discuss the previous year question paper, that is Clat paper 2025. And today, in order to make you understand certain legal things, we have decided to take legal reasoning classes. You must be aware that in the CLAT examination, there are five sections. And the most important among them is the legal reasoning section. And this is one section which you people have never studied. For example, reading comprehension is something you have studied in your class 12th. You have already, there are in English paper, there is reading comprehension section is there. And similarly, the same kind of question is asked over here. Then we have general knowledge, which you read in newspaper, you listen in TV, on TV and other media sources. Then we have logical reasoning. It's again a kind of reasoning. It's nothing to do with specialized knowledge, but at the same time that requires some practice in order to crack this examination. Some arithmetic questions are there, and then the most important being the legal reasoning section of it. Now, please understand the consortium of the national law schools. They also do know that you people are still not a lawyer. So the precise, you don't have to fret. You don't have to be very concerned about the specific sections of the laws, because earlier if you see the CLAT pattern, they used to ask particular sections also, which section talks about, say, theft. So they would be giving three four sections over there, which is not now the case. Now everything is based on a passage which contains some factual propositions and some and also some legal ideas, or legal part of it, something legal about it. So you have to just read the passage, apply the legal principle which is given in the passage, and then come to your answers. Now, I would say that in the whole CLAT paper, the most important thing which you need to do is to have a very good reading speed, because you won't be able to finish your CLAT paper in case you are not good reader. So over a period of time, try to develop your reading speed, try to enhance your reading speed. Let's see this particular question. Now, this question 10, it talks about, let's see, the context is very clear. It is about children. Children come in contact with criminal justice system either as victim or witnesses to a crime, or as children in conflict with law. So very interesting thing is there is a word here being used here, children in conflict with law. So in general terms, if we talk about any criminal trial, a person against whom legal proceedings have been instituted is called a criminal or an accused. But the nomenclature, when Juvenile Justice Act is there, where laws concerning the children are there, they are very mild and something like children in conflict with law. As CICL, children in conflict with law, they could be alleged of accused or recognized as having broken the law by committing a crime. According to National Crime Bureau NCRB report, so now it is referring to a report 2021. So some facts have been given over here. You have to assimilate, understand the facts well, because the question which is going to come on, you are going to get, will be based on fact also. India recorded a total number of 1,49,404 instances of crimes against children in 2021, a rise of over 16% from the previous year. In terms of percentage, the top categories under the crime against children were kidnapping. So, which were the top categories under crime against children? Kidnapping and abduction, followed by cases registered under POXCO for this particular act, which is prevention of protection of children against sexual offenses. Further, the NCRB report revealed that the total cases 53,874 were registered under POXCO section. Sexual offences against children shows a steady ascent, with 47,221 such cases being recorded in 2020, 47,335 in 19. In 2019, as many as 32,269 cases were registered across the country, while 2021 report registered a decline of 3.5% of recording in 31,170 cases. So these are some factual propositions given over here. Now, let's come to the second part of it. Criminal justice system of any country broadly refers to agencies of the government charged with enforcing laws, adjudicating crime, and correcting criminal conduct. The main objective of the criminal justice system is deterrence. What is the main objective of the criminal justice system? It is deterrence. Okay? That is to punish that is to punish the transgressors and the criminals, and to maintain law and order. So what is the objective? Is punishment of the transgressors and the criminals, and to maintain law and order in the society. Globally, children and young people are routinely exposed to various forms of violence. If they are before the criminal justice system, they are at risk of physical and psychological abuse, sexual assault, and other harms, including inadequate educational opportunities, poor and outdated vocational training. They face several challenges, including mental, emotional. So, which kind of challenges they face? Mental, emotional, behavioral disorder. Children who are victim of violence or exposed to violence during childhood are more likely to have difficulty in school, abuse drugs or alcohol, act aggressively. So, which kind of symptoms may develop later on? Drug abuse, alcohol abuse, aggressive behavior, depression, mental health problem, and in criminal behavior as adult. So now let's see how what are the questions over that. So factually, you are clear what is the objective of the criminal criminal justice system, the facts which were given there. Now let's see the questions. You'll find very direct questions on based on the fact given in the para. Which of the following issues children who are victims of violence during childhood face in life, as per the author of the above passage? So your context is this passage only. Even if you know certain other information, you don't have to bring it here. You have to. It's like reference to context kind of question. So it says they may have difficulty in school. We just saw that. They may abuse drugs or alcohol and suffer from mental health problems. We just underlined over here. They may act aggressively and engage in criminal behavior. We just saw over there. All the above. So what will be the correct answer here? Yes, it is D, all the above. The correct answer is going to be D, all the above. Now come to the next question. What is the primary objective of criminal justice system as mentioned in the passage? So let's see what we have already underlined that. The main objective of the criminal justice system is deterrence, that is to punish the transgressors and the criminals. So what would be the answer here? Rehabilitation of the offenders? No. Reformation of the offenders? No. Protection of victims from offenders? No. It is B. Punishment of the offenders. Understood? Now let's move to the other question. Uh, 55. The National Crime Record Bureau in India is responsible for what? Conducting, conducting forensic investigation of records of criminal. So it's talking about whether they do investigation. No, they don't do any kind of investigation. Maintaining a national database of fingerprints of criminal, that is there. Compiling and analyzing crime data, maintaining a national database for enforcement of criminal law. The answer is compilation. They are largely functioning as nodal agency for compiling and analyzing the crime related data. Which category has the highest number of cases under crimes against children according to the NCRB report 2021? If we just go back to the passage, we have underlined the top categories under crime against children were kidnapping and abduction. Now let's see the options here. uh, POXCO, kidnapping and abduction, sexual offenses, all of the above. So, what will be the correct answer here? The correct answer is kidnapping and abduction. Now, let's see question number 57. Which one of the following is the correct explanation of the term POCSO used in the passage? Now, let's see. It's an act which is there and which aims at punishing those people who violate or sexually exploit children. So, apart from the old IPC or BNS which we have, this is a special act which is there especially to protect children from sexual offenses, and it has very stringent provisions for punishment. Protection of children from sexual offenses, prosecution of criminals of sexual offenses, protection of children and women from sexual offenses, none of the above. What will be the answer? A. Protection of children from sexual offenses. Now come to question 58. What risk do children face when exposed to criminal justice system as per the passage? So if we go back to the previous passage, you will find that uh, they are at risk of physical and psychological abuse, sexual assault, other harms, so and so. It was very much there. So let's see what is their uh, what risk do children face when exposed to criminal justice system as per the passage? Limited access to vocational training, exposed to risk of physical abuse, mental health challenges, and behavioral disorder, all of the above. The option is all of the above. Understood? So if you see the question, even though it was dealing with something which you have not studied as a student, you might be initially thinking that this is a legal topic, how I'm going to solve it. But if you read it carefully, you will find that the answers are very much over in the passage itself. It's more like reading RTC, which we did in class 12. Now, coming to the next question, question 11. The 42nd Constitutional Amendment Act 1976 introduced the concept of environmental protection in an explicit manner into the Constitution through introduction of Article 40. Which article? Article 48A. Now, just the moment we come across Article 48A, just in at the background of your mind, just think where this Article 48 is. Is it a part of fundamental right, or it is a part of DPSP, or it is the part of fundamental duties? And Article 51 AG. Okay. So Article 51A, which is what is it talks about Article 51A? Yes, it talks about fundamental duties of every citizen. And Article 41, 48A, you will find it in the directive principle of state policy. In many judgments, the Supreme Court ruled that both the state and its residents have the fundamental duty to preserve and protect their natural resources. So there is a duty cast upon every resident to protect and preserve their natural resources. The recent judgment obliquely makes way for the enforceable right and a potential obligation on the state unless the same is overturned by an act of parliament. India is signatory of various international environmental conservation treaties under which India has the binding commitment. So, which kind of commitment is there? Binding commitment to to reduce carbon emission. During COP 2021, India signed a Paris Agreement along with 196 countries, under which universally binding agreement was made. So it's a binding agreement was made to limit greenhouse gas emission to the level that would prevent global temperatures from increasing to more than 1.5 degrees Celsius before the Industrial Revolution. India has committed to generating 50% of its energy through renewable resources and will generate 500 gigawatt of energy from non-fossil fuels by 2030, reducing the carbon emission by 1 billion ton. Additionally, India has committed to achieve net zero carbon emission target by 2070. So this passage is talking about certain commitments India has made by becoming signatory to the Paris Agreement, and it talks about the fundamental duties of a citizen and the state's obligation to maintain, preserve and protect the natural environment. Let's see what kind of questions have been asked on this passage. Acha, then the passage is a bit more. Supreme Court's March 2024 verdict builds on the bulwark of jurisprudence in place since 1986. And through various other judgments, the Supreme Court has recognized the right to clean environment along with right to clean air, water, and soil free from pollution, which is absolutely necessary for enjoyment of life. Any disturbance with these basic elements of environment would amount to violation of Article 21. And this is one of the most important articles in the Constitution of India. Why? Can anyone think of it? Because it guarantees right to life and personal liberty. That's fundamental. Unless and until you have the right to live, all the rights, all the fundamental rights and duties don't have any meaning in absence of Article 21. It also establishes duty of the state to maintain ecological balance and hygienic environment. Although right to clean environment has existed, by recognizing the right against climate change, it shall compel the state to prioritize environmental protection and sustainable development. So this is the whole draft. Now let's see what are the questions asked in this. Question 59. In which among the following changes were introduced for environment protection through the Constitution of India 42nd Amendment Act? So we just saw over there fundamental rights were from day one of the Constitution when it came into picture. Fundamental duties. Very interestingly, you will be very surprised that our original Constitution did not have fundamental duties. We had a very big part given to the part 3 of the Constitution catering to to the fundamental rights, but there were no fundamental duties in the original Constitution, which came into force on 26 January 1950 completely. So fundamental duties were added at that point of time. And DPSP, Directive Principle of State Policies. So it is asking the Amendment Act of 42nd Amendment Act impacted what all, where all changes were brought. So fundamental duties and directive principles of state policies. We saw that 48A and 51AG just above in the passage. So the correct answer would be B. The nature of binding commitment of India to reduce carbon emission through signing of various international environmental conservation treaties, especially the Paris Agreement, may be described as the signatory shall take adequate measure to reduce carbon emission. The signatory may take, okay. So it's trying to check which kind of, binding, how much binding it is. The signatory should explore the possibility of reduced carbon emission. The signatory may formulate. So, as we read in the previous para, uh, if you see that binding commitment to reduce, binding agreement. So definitely the answer cannot be may, should, may formulate. It is A. The signatory shall take adequate measures to reduce carbon emissions. Now, coming to question number 61. Under Article 51AG of the Indian Constitution, it is specifically mentioned that citizens shall have the duty to protect and improve the natural environment. That includes, so you need to, Constitution, you need to go through it, these things, then only you will get to know because it is missing over there. Uh, Rivers and lakes, forest and wildlife, all living creatures, only A and B. So rivers and lakes, that is very much there. Then forest and wildlife is there. All living creature is a very broad word which is not there in Article 51 AG. So you need to also go through those fundamental rights, particularly DPSPs, and very importantly, the fundamental duties. Let's see the next question. 62. As per the aforementioned passage and decision of the Supreme Court, the fundamental duty to preserve and protect natural resources is upon the state only. Can you say? What about fundamental duties of the citizen? Citizen alone have the fundamental duty. So neither the state is 100% responsible, nor the citizens are 100% responsible. Both the state and citizen have the duty to preserve and protect natural resources. State's duty to maintain ecological balance and citizens' right against climate change. Uh, so the answer would be D, which is the state's duty to maintain ecological balance and citizens' right against climate change. Now, question number 63. According to the passage, what makes India committed to reduce carbon emissions? A, because of being a signatory of international environmental conservation treaties, because of Supreme Court verdict, which obliquely make way for an enforceable right, because of policy decisions of government, because of Constitution of India, 42nd Amendment Act. So the answer would be being a signatory to environmental conservation treaties. It would be A. Now, question 64 talks about the passage mentions that any disturbance which with these basic elements of environment would amount violation of Article 21. Article 21 of the Constitution deals with right to equality, right against exploitation, right to freedom of residence, right to life and personal liberty. The answer is D. Now, let's see the next passage, and this passage is based on the concept in contract law and law of contracts. And this is a very old law. If you see the Indian Contract Act, it is 1872. And it has been going since then. This is still tested and tried, and it's one of the best codified laws on contract in the world. The Contract Act 1872 deals with contract law in India, its right, duties, exceptions arising out of it. Section 2H of the Act gives the definition of contract, which is simply an agreement in what is a contract. If somebody asks you what is the definition of the contract, an agreement enforceable by law is a contract. So, if I may digress here, all the contracts are agreement, but not all agreements are contract. So when we are going to understand, we are going to have our classes, concept classes, we will be dealing with all these things. Right here, let's proceed. To understand the difference between void agreement and voidable contract, it is important to talk about section 2H, 2A, 21, 2D, 14, 16.3, and 15, 24, 28 of the Indian Contract Act. Now it talks about two kinds of agreements. Now they are talking about void agreement. Void agreement means null. You must have heard the word somewhere, read somewhere, null and void. So in order to emphasize void, people also use the word null. Null and void. Void agreements are fundamentally invalid, making them unenforceable by default. So if an agreement is, if we can say, we can show that this agreement is void, any person affected by that particular agreement cannot even go to the court because it is unenforceable by law. An agreement which you can take to a court in order to enforce it is an enforceable agreement, and that becomes a contract. These agreements cannot be fulfilled as they consist of illegal elements, and they cannot be enforced even after subjecting it to both the parties. So you will just we are getting an idea from this passage that void agreements have which what all elements they have. They have illegal elements, and they cannot be enforced. Since they have illegal elements, that could be the object of the contract, that agreement is illegal. The how you are performing it is illegal. There are many things. It's a matter of complete class will have later on, even after subjecting it to both parties. However, in case of voidable contracts, so another kind of contract is voidable. One is void. That means it did not exist in the eyes of law from the very beginning, from day one. The day one it was signed, for in the eyes of law, it was nothing, a piece of paper, a shred of paper. That's it. However, there are another kind of contracts which are we call voidable contracts, which may be declared, which may be later on declared void contracts. Those are called voidable contracts. The agreement is initially enforceable at the time of making that agreement is enforceable, but it is later on denied at the option of either of the parties due to various reasons. So initially enforceable. For example, if I say tomorrow you go to your brother who is 5 years old, and you create a paper and say ki all the property what my father had, I'm giving all my property to my elder brother. That means you, and you make your 5-year-old brother to sign that particular document, gift deed. I'm saying, would it tomorrow can it be enforced in the court of law? Common sense says no, because your brother is 5 years old, is a minor, and minor cannot be bound by any contract. So at the time of signing, say if he was 5 years old, and when he becomes 18 years old or 21 years old, he ratifies that. He says that, okay, what I have written, 15, 17 years ago, I abide by it and I support that thing. At that point of time, when he says, when he becomes a major, and then he accepts that, then it may become a binding thing. But say, for example, when he turns 18 and he says, no, 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 I am not bound by this particular thing which you made me to sign because I was a minor. So that very document will become a voidable document. It will be a voidable agreement at the option of your brother, who is the affected party here. If he chooses to say so, he can get out of this agreement, and you cannot enforce it in any court of law. But it is later on denied at the option of other. Next page. Unless rejected by the party, this contract will remain valid and enforceable. So, unless it is rejected by a party, this contract will remain valid and enforceable. So, if your brother decides not to reject it, this contract will remain valid and enforceable. When he can reject, when he attains the majority. The party who is at the disadvantage due to any circumstance applicable to the contract has the ability to render the agreement void. So, as I told you, your brother who was 5 years old is at a disadvantage, and he can render the agreement void if he chooses to. A void agreement is void ab initio. So this is a Latin term, void initio, ab initio. Yeah, that means void from the very beginning, unenforceable, nothing in law from the day one, very beginning, making it impossible to rectify any defect in it, while voidable contracts can be rectified. Okay. In case of a void agreement, neither of the parties is subject to any compensation for any losses, but while voidable contracts have some remedies. So, if there is a void contract and you know mm, some loss happens to one of the parties, the other party cannot approach a court of law to get compensation for that very loss in case of a void contract. Now, in cases of voidable contracts, there are still remedies available to the affected party, disadvantaged party. A valid agreement forms a contract that may again be either valid or voidable. The primary difference between a void agreement and a voidable contract is that void agreement cannot be converted into contracts. So they are dead letters from day one. You cannot convert it into any contract. Now, see the question based on the concept which is discussed here about the contracts, particularly void and voidable contracts, agreements. Which of the following best describes a void agreement? So, we had discussed earlier what is a void agreement, which is completely unenforceable, which is nullity from the day one. Agreement that is valid until declared invalid by a court? No. An agreement that has no legal effect from the beginning, an agreement that is legally enforceable, an agreement that can be enforced if one party chooses to do so. So clearly the answer is B. A contract between two parties to rob a bank. So contract between two parties to rob a bank. So what is the objective of the contract? Robbery, commit a crime. Can, say for example, one of the persons, he on the day of robbery, he does not reach there, and the other person suffers, say, a loss of 50,000 rupees because he has prepared, he has purchased a gun, and he has taken a van and mask and everything. Now, can this person who has spent 50,000 rupees file a case for damages or recovery against the other party who did not turn up that day for the robbery purpose? Obviously, no, because the object of this contract, this agreement was illegal. That was to rob a bank and share the proceeds equally, can be termed as. So, what would be? It is a void contract, valid contract, voidable, or legally enforceable contract. Since the objective of this contract, this agreement was to commit an offense, it is clearly a void contract. An agreement made by an adult but involving minor children, where the signatory is a minor child himself, this agreement would be a valid and enforceable agreement, a voidable agreement, a void agreement, an agreement that cannot be enforced by the minor. Made by an adult but involving minor child. So this is something. Say for example, a major is taking a decision on on for a minor who, for example, say his mother and father are not there. He's making some decision on behalf of the minor for the welfare of the minor. That in that case, that can be a valid and enforceable agreement against the minor also. But again, we will see in when we will have discussion on this particular Indian Contract Act, how it is there. Which of the following scenarios would most likely result in void agreement? So we are looking for which would be a scenario which will make an agreement void. An agreement signed by someone under duress, धमकी देके किसी से साइन कराया जा रहा है. A contract with mutually agreed terms to sell a house. An agreement to pay 10 lakhs on getting a government job. A contract with a minor who understands the term. You know, here you, if you don't know the concept over here, you may not be able to attempt this question because uh, you know there is a concept of wagering agreements, which is based on the outcome of something happening or not happening. For example, a small example could be a life insurance term life plan, which it's a kind of contract over there. So here, which of the following scenario would most likely result in a void agreement? An agreement, here the answer would be C, an agreement to pay 10 lakhs on getting a government job, because this is a wagering contract, what we call. An agreement made without consideration is generally, if, for example, I'm selling you my house and you don't pay me anything, there is no consideration, and we are not brothers and sisters. There is no relationship of father mother or something like that. And if I'm selling your my house to you and you are not paying anything to me, that becomes a void agreement, because without consideration there cannot be any contract. Consideration is the most important ingredient of a valid contract. So, agreement without consideration, it's a void agreement. I would stop here, and I would next questions. Further questions would be dealt by my colleague, my friend, Mr. Dheeraj Jha, who would be discussing other questions with you. Hope you have understood the things, and largely you have got an idea that you have to apply the concepts based on passages given over there. And concepts would really be helpful when you are reading these passages. So, our classes, when we are going to have, would be more about concepts building, because once you have the concept, you can read any passage and you can perform very well, exceptionally well in your examination. Thank you so much. Thank you.